5 seconds to go. Start. Relying on the above said order, learned counsel for the appellant submits that respondent state ought to get first the order dated 10th March 2016 granting bail to appellant cancelled before seeking custody of the appellant. It may be true that by mere addition of an offence in a criminal case in which accused is bailed out, investigating authorities itself may not proceed to arrest the accused and need to obtain an order from the court which has released the accused on the bail. It is also open for the accused who is already on bail and with regard to whom serious offences have been added to apply for bail in respect of new offences added, and the court, after applying the mind, may either refuse the bail or grant the bail with regard to new offences. In a case, bail application of the accused for newly added offences is rejected, the accused can very well be arrested. In all cases where accused is bailed out under orders of the court and new offences are added, including offences of serious nature, it is not necessary that in all cases earlier bail should be cancelled by the court before granting permission to arrest an accused on the basis of new offences. The power under sections 437(5) and 439(2) are wide powers granted to the court by the legislature under which court can permit an accused to be arrested and commit him to custody without even cancelling the bail with regard to earlier offences. Sections 437(5) and 439(2) cannot be read into restricted manner that order for arresting the accused and commit him to custody can only be passed by the court after cancelling the earlier bail. Coming back to the present case, the appellant was already into jail custody with regard to another case, and the investigating agency applied before Special Judge NIA Court to grant production warrant to produce the accused before the court. The special judge, having accepted the prayer of grant of production warrant, the accused was produced before the court on 26th June 2018 and remanded to custody. Thus, in the present case, production of the accused was with the permission of the court. Thus, the present is not a case where investigating agency itself has taken into custody the appellant after addition of new offences. Rather, accused was produced in the court in pursuance of production warrant obtained from the court by the investigating agency. We thus do not find any error in the procedure which was adopted by the Special Judge NIA Court with regard to production of appellant before the court. In the facts of the present case, it was not necessary for the special judge to pass an order cancelling the bail dated 10th March 2016 granted to the appellant before permitting the accused appellant to be produced before it or remanding him to the judicial custody. In view of the foregoing discussions, we arrive at the conclusions in respect of a circumstance where, after grant of bail to an accused, further cognizable and non bailable offences are added. Stop.